We are going to continue now and take a look at some legal matters. Let's unpack some legal developments that carry real consequences. The Madlanga Commission resumes its public hearings on the 26th of January 2026. The Commission will continue hearing matters linked to allegations raised during its initial phase as it moves into the next stage of proceedings. The Constitutional Court has ruled that whilst the extradition process of Murari Choloto also was flawed, that flaw does not invalidate the criminal case itself. And at the very same time, Julius Malema, of course, returns to court with final heads of argument on sentencing. That's set for the 15th of April. It's a crucial stage just before a sentence is handed down. So to help us unpack what all of this really means in law, why it also matters beyond the courtrooms this morning, we're going to be joined by legal analyst, Advocate Mbalenhle Mthembu. A very good morning to you, Advocate Mbalenhle, and thank you for your time at this hour.
Good morning, Lizo. Thank you for having me.
All right, so there's lots to get through. Perhaps we can start off with what happened. We look at the stories that really hinge on process versus substance, the Apex Court ruling, the extradition ruling obtained. Let's get into that. So for viewers at home, what exactly did the court mean when it said that the extradition process was flawed, but that the criminal case remains valid? At this point, how is the court trying to draw a line between procedural legality, or illegality rather, and substantive justice at large from your vantage point?
Okay, so in this case, the Court was differentiating between substantive defects and procedural defects. So in this case, the merits of the NPA's case against Cholota have not been established yet. They are still dealing with the procedural aspect. So in this case, the Court highlighted that the extradition of Cholota from the US was flawed in terms of procedure, that the NPA didn't have the requisite authority to request that extradition. But the charges against Cholota still stand, the criminal case still stands. So the matter has been remitted to the Free State High Court to properly ventilate the other grounds on which Cholota challenges that extradition. So we haven't yet gotten to the merits of the criminal case. We are still dealing with the procedural aspect.
Because the issue of jurisdiction also came to the fore. And so, we're trying to ascertain that if an accused person was brought into the country improperly, why doesn't that then automatically collapse the entire prosecution?
Okay, so in this case, the administration of justice and the need to prosecute crimes has to be balanced with the rights of individuals. So the courts need to determine to what extent did those procedural defects affect the rest of the criminal trial. So depending on what exactly the procedural defect was and what extent it affected the trial, then the court would make a determination of how far it goes into affecting the validity of the case.
Because even if we're looking at the rights of the accused, asking whether the ruling weakens the rights of the accused persons, does it simply prevent technical loopholes from overriding accountability? We're trying to understand where the Constitution draws that balance, only because there are implications at large, both for international law, when we look at, cooperation between states, risk of damaging diplomatic ties as well. Tell us a little bit more about those consequences.
Absolutely, Lizo. I think that this ruling, if anything, it bolsters the rights of individuals, the rights of accused persons, because the court confirms the fact that the extradition was unlawful. The procedure that was employed by the NPA to bring Cholota into the country was unlawful. So if anything, I think it highlights that the means don't justify the end, and that procedure is extremely important in order for the rule of law to not be undermined, and in order for, as well, just for the rights of individuals to not be undermined in the process of bringing accused persons, rather, to be accountable for the crimes that they are charged with. So it is a delicate balance. It is about still upholding the rule of law. It's still about the need to prosecute crimes, but the process as well is just as important.
Yeah.
And I think that it's also an important thing for the NPA as well to just be highlighted in the sense that procedure really does matter in this case, although it won't completely collapse criminal cases, but it is very important to follow the letter of the law.
Because we obviously also looking at what precedents this now also sets at large. Tell us a little bit more about that as we wrap up that case.
Yes, so it basically has really established and provided legal certainty and clarity in the fact that the power to extradite accused persons and bring them to the country to be accountable for charges against them lies within the minister. In this case, the NPA acted ultra vires. In other words, it acted outside the scope of its powers. So it provides the clarity in that it is the minister's role. The NPA is a domestic prosecutorial body and doesn't have the requisite authority to engage with foreign states in terms of extraditing accused persons. The people that have the authority for that is the minister. So it is very important as well for international relations. And the NPA is domestic. It does not have the authority to represent the country and engage with foreign states in these types of matters.
Well, those nitty-gritties obviously just being fine-tuned there by the Apex Court, and obviously monitoring that case rather closely to see what develops from here too. But there was obviously another big case that we were following, and that was the Julius Malema, of course. Sentencing is going to happen on the 15th of April. As we see the final heads of arguments being submitted. I mean, for people who are not privy to that process, why it has happened, why that phase is so important before a judge actually imposes, its sentence or their sentence. Tell us a little bit more about what is transpiring as we edge closer to the 15th of April.
Okay, so once an accused person has been convicted, we move on to what we call the sentencing phase of the proceedings. So at the sentencing hearing, it's an opportunity for both sides, the prosecution as well as the defense, to make submissions to the court regarding sentencing. So with the prosecution, they would be making submissions in aggravation of the sentence to be imposed, and the defense would be making submissions in mitigation of the sentence to be imposed.
Because Advocate Mbalenhle, we're obviously looking at what the court considers, right, at the sentencing. The factors, what factors does the court weigh in when it comes to punishment, when it comes to deterrence, when it comes to rehabilitation? This is all happening in a political context as well. So all of these factors have to be balanced quite well.
Yes. So in sentencing, the court looks at what we call the Zin triad, which the court has to weigh the seriousness of the offense, the personal circumstances of the convicted person, as well as the interests of society in general. So the court looks at all of those factors and really determines the appropriate sentence. And many charges carry minimum sentencing requirements. For example, an unlawful possession of a firearm charge carries a minimum sentence of 15 years for a first-time offender. So in that case, the defense would have to make submissions to the court and really state to the court whether there are substantial and compelling circumstances that would allow the court to deviate from the minimum sentence that is mandated by law in the Criminal Law Amendment Act. So the court does consider all of those factors as well as the submissions from both sides to really determine what would be the appropriate sentence in this circumstance.
Some are trying to ascertain whether there is in fact room to maneuver and whether final heads can materially influence the sentence. Is the outcome largely already set at this stage? What's happening on that front?
So basically, the reason for a sentencing hearing is there is room to maneuver. So at this stage, what final heads are really written submissions that outline the arguments that are to be made in courts by either side. So each side submits their written final heads of argument. They submit those to the court as well as to each other so that everyone is basically aware of the submissions that will be made in court, as well as the authority that is relied on by either side in making those submissions, so that each side can properly answer as well to the submissions that are being made. So there's always room to maneuver at the sentencing phase. There's always submissions that can be made either in aggravation of the sentence to be imposed or in mitigation of the sentence to be imposed. So it's just those written submissions that limit the argument to what has been written on paper.
You know, understanding this process becomes crucial, and I alluded to this earlier on, but the context that all of this happens obviously is also important. Political status versus equality before the law. You know, some are questioning whether the court treats a high-profile political figure a little differently at sentencing, or does the principle of equality before the law actually, become strict? Is it strictly applied here? How does the court guard against such perceptions of bias as well? And what are his appeal prospects once sentencing is handed down? What are some of those other legal avenues that remain open?
Yes. So according to our constitution, everyone is equal before the law, and the court ought not to treat any person, regardless of their stature, any differently. And we've got what we call separation of powers in our country. We've got the three arms of government. We've got the executive, the legislature, and the judiciary. The independence of the judiciary is highly important, and interference from the executive and the legislator is highly separated. So the court really does treat everyone equal before the law. It's all about what the law says, what legal precedent says. Essentially, the court is guided by the letter of the law, even in imposing sentences. Okay. The court doesn't make up the law as it goes along. It is essentially guided by those principles. And once sentence has been imposed, there are obviously always prospects to appeal, to review. It really does depend on what those grounds of review are. If there are prospects of appealing the matter, the defense would obviously have to make submissions in whether the court misdirected itself in how they imposed sentencing. Okay. And if they would like to take the matter on review, it's all about whether there were any procedural irregularities. There is obviously no right of automatic appeal in regional magistrates court matters. It would have to be an application that is made for that to happen.
I need to wrap up, and so for the interest of time, just as we swerve away from that second case, I mean, the Madlanga Commission resumes. So the Commission speaks of phase 1, phase 2, phase 3 as well. From a legal perspective, talk to us about why these phased approaches are so important. Phase 2, I mean, we're looking at evidence that was also not tested, and we're looking at how sensitive it now becomes legally and politically as well. What's set to transpire from here into as it resumes?
Yes, so essentially, phase 1 was just all about airing, substantiating, and corroborating the allegations that were made. So the rules of evidence in commissions of inquiry are slightly different from the rules of evidence in courts. Nothing is essentially ruled inadmissible in commissions of inquiry, and witnesses are allowed to freely testify, and that evidence is essentially not tested for its admissibility, its weight, etc., as you would do in a court of law. So phase 2 of a commission of inquiry is then when witnesses reply to the allegations that are leveled against them. And we know that the interim report has been submitted to the president. And at this stage, the report would merely to let the president know the problem or the extent of the problem that we have in regards to these allegations into criminality, interference, and corruption in the criminal justice system. And at this stage, it's highly unlikely that any recommendations allegations are being made in that interim report, it's essentially to highlight the problem or the extent of the problem, if any. And as the commission resumes, of course, it's continuation in reply to those allegations. And that's important because our justice system really holds highly the audi alteram partem rule, which is here the other side. Every party has the right to respond to allegations being made against them and to make their own submissions. And once the commission wraps up, it's then when a final report would be made and then recommendations being made to the prosecuting authority, etc., on what the next steps against these individuals would be.
Well, thank you for joining us this morning, for breaking all of that down. I mean, we're going to continue to track all those matters as they unfold. Advocate Mbalenhle, Mthembu, legal analyst, weighing in on some of those legal matters at this hour.